Welcome back to the Deep Dive. Today, we are staring down a legal nightmare that, well, it keeps city attorneys awake at night and makes every parent hold their breath.
Oh, absolutely.
It's a scenario that seems so simple on the surface, but it just drags us into one of the most complex battles in tort law.
It really is. It's that classic collision between a government's need to function and, a citizen's right to justice.
Exactly. Picture this. It's a sunny Saturday. You're at a Little League game. A kid, we'll call him Christopher, the plaintiff in our case today, is chasing a fly ball in the outfield.
Yep.
He steps into a hole that just shouldn't be there. Snap. He's injured. The parents, of course, sue the city for negligence. I mean, you broke it, you bought it, right?
Yeah, straightforward.
But the city steps up and says, stop right there. You can't sue us. We have sovereign immunity.
And just like that, a personal injury case transforms into this huge constitutional and statutory brawl.
Right.
The city isn't just denying they were sloppy, they are claiming they're literally untouchable.
And that is our mission today.
Yeah.
We are going to conduct a rigorous examination of municipal immunity. Specifically, we need to understand the high-stakes battle between two legal concepts: discretionary functions versus ministerial acts.
Okay.
I'm going to be the inquisitor today. I'll present the facts, the hypotheticals, and I'm going to push you on the logic. I need you to be the analyst.
I accept the challenge. This area of law is incredibly nuanced because it tries to answer a really fundamental question. When is a government worker just a person who made a mistake? And when are they an extension of the state exercising power?
So give us the roadmap. How are we going to dissect this?
We'll follow a three-part structure. First, we are going to define the statutory rule for immunity under Connecticut law. We need to know the source code.
Okay.
Second, we'll distinguish between judgment calls, what we call discretionary and mandatory duties, which are ministerial. And finally, a structured VIRAC analysis of the landmark case Peeples v. North End Baseball League to see how an informal habit can just strip a city of its immunity.
Let's get right into the doctrine then. To understand the game, you have to know the rules. What is the governing statute here regarding a political subdivision's liability?
The foundation for everything we're discussing today is Connecticut General Statutes, Section 52, 557N, A to B. That is the controlling authority.
And what does that statute actually say?
The general rule is this: a political subdivision, so think a city or a town, is not liable for damages caused by negligent acts or omissions which require the exercise of judgment or discretion as an official function.
Okay, let's unpack that. If the act requires judgment, the city is immune. They get a pass.
Right.
But surely they can't be immune for everything. I mean, if a city employee runs a red light and hits me, they can't just say, I used my judgment to run the light.
Correct. And that brings us to the corollary. By implication and, by the statutory context, liability does attach to ministerial acts. This is the binary we have to work with.
So it's one or the other.
Exactly. If the act is deemed discretionary, the city walks away total immunity. If the act is deemed ministerial, the shield drops, and the city can be sued for negligence.
That distinction is the whole ballgame. But judgment is a pretty vague word. Every action requires some brain power. How does the court actually distinguish a discretionary act from a ministerial one? What is the specific legal test?
To find that test, we look to the precedent in a case called Dimicelli. The court laid out a really clear bifurcation there. The hallmark of a discretionary act is the exercise of judgment.
The choice.
It represents a choice. It is when an official has to weigh options, balance competing interests, or make a policy decision.
And on the flip side, how do we define ministerial?
A ministerial act refers to a duty which is to be performed in a prescribed manner without the exercise of judgment or discretion. But here is the critical part, the source of the duty.
It's a source.
To be ministerial, there must be a directive.
A directive, like a law.
It could be. It could be a city charter, an ordinance, a rule, a policy, or a regulation that compels the act. If there's a rule book that says you must do X, then doing X is ministerial. The thinking has already been done by the policymaker. The worker is just the hands executing the task.
So if you're deciding what the rules should be, you are immune. If you're just following the rules, you are liable if you mess up.
Precisely.
Before we apply this to our main case, I want to make sure we really feel the difference. I want to propose a visceral hypothetical to test this boundary.
Go ahead.
Let's get out of the courtroom and onto the street. Imagine a city sanitation worker operating a massive garbage truck.
Okay.
He's driving through the city. He's also operating the compactor on the back. It's hot, he's behind schedule, and he's stressed.
Okay, I have the visual.
Let's look at two different actions. First, he's driving down a main avenue and sees a massive traffic jam ahead. He decides to take a shortcut down a narrow side street to stay on schedule.
That is a perfect example of a discretionary act.
Why? He's just driving.
Because the driver is evaluating traffic patterns, time constraints, road conditions, he is exercising judgment to decide which route to take.
Right.
There is no ordinance that says garbage truck 404 must always take Main Street. He has to think. If he hits a pothole on that shortcut and jars the truck, causing some minor damage, he and the city are likely immune. It was a judgment call.
Okay, now for the gross part. He pulls up to a stop. The manual for the truck, the safety binder in the glove box, explicitly says, do not pull the trash compactor lever until you visually verify no one is standing near the hopper. That is the rule.
That is a clear directive.
But let's say he's tired or just lazy. He assumes no one is there. He doesn't look. He just pulls the lever. And tragically, he crushes someone's hand who was throwing in a late bag of trash.
That is a ministerial act, or, well, a breach of a ministerial duty.
How does the court see that differently than the driving?
Because the manual removed his judgment, it didn't say pull the lever when you feel it is safe. It didn't say use your discretion.
No wiggle room.
It said verify first. It prescribed the manner of the act. By pulling that lever without looking, he breached a mandatory directive. He had no judgment to exercise. He just had to follow the rule. And therefore, the city is liable.
That makes it crystal clear. Judgment versus a checklist. Now that we have that framework locked in, let's transition. Let's analyze Peeples v. North End Baseball League of Bridgeport, Inc.
Yeah.
We're going to do this systematically. First, what are the legally dispositive facts?
All right, so here's the factual landscape. The plaintiff is Christopher Peeples. He was injured when he stepped into a hole in the outfield during a game at the North End Baseball League.
And the defendants?
The defendants are the city of Bridgeport and its Director of Parks and Recreation, Charles Carroll.
And the city responded aggressively.
They did. They moved for summary judgment. They argued that maintaining a park is a broad discretionary function involving budgets and staffing, so therefore they're immune.
But the evidence showed something else.
It showed something interesting. The city had employees, specifically a man named Mr. Karpus, who had a practice of prepping the field. And crucially, supervisors testified that if an employee saw a hole, they were expected and required to fix it or report it.
Expected and required. That sounds like the pivot point.
Yeah.
So based on those facts, what was the core legal issue regarding the motion for summary judgment?
The legal issue is precise. Whether the city's failure to inspect the outfield and repair the hole was a discretionary act, which would entitle them to immunity, or a ministerial act, which would subject them to liability.
And to decide that issue, the court has to use a measuring stick. What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements for us.
Of course. The court applied the standards from Dimicelli and Bergolta regarding the statute. For the plaintiff to win here, to prove this was ministerial liability, there are 3 specific hurdles or elements relevant here.
Okay, what's the first?
Element 1, existence of a directive. Was there a policy rule or directive, and this is key, formal or informal, requiring the act?
And the second?
Element 2, prescribed manner. Did that directive mandate the act be done in a specific way, removing independent judgment?
And what's the last part?
And finally, there is an alternative exception. Let's call it element 3, identifiable victim imminent harm. This asks, even if the act was discretionary, was the danger apparent and the victim part of an identifiable class?
Thank you. That gives us our structure. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, the existence of a directive?
This brings up a fascinating sub-issue. Does an informal policy even count as a directive? The city argued that there was no written statute saying fix every hole.
Which is a fair argument. Usually laws are written down.
True, but the court looked to the Vergolta case. The sub-rule there is that policies regulating the timing or frequency of inspection can be ministerial, even if they are informal. And in applying this to the facts of Peeples, the court found significant evidence that the city had an informal policy. Supervisors Negron and Carroll testified explicitly in depositions that Mr. Karpus was supposed to inspect and not permitted to walk right by a hole.
So the testimony created the law, in effect.
Essentially, yes. The court's conclusion on this element was that a reasonable jury could find a mandatory directive existed, even without a written statute, because the supervisors made it clear that fixing the hole was not optional.
Understood. Now, what about the second element, the prescribed manner? The city had a pretty nuanced argument here about the nature of the work itself.
This is where the city tried to get clever. The sub-issue here is, did the employee have discretion on how or whether to repair the hole? The city argued, look, fixing a hole requires judgment.
How so?
They said, how much dirt do you use? Do you tamp it down? Do you use a shovel or a rake? They claim these micro-decisions made the whole act discretionary.
It does sound like it involves some choice. It's not a robot pressing a button.
The court rejected this reasoning. They applied the sub-rule from a case called Williams v. Housing Authority. That case states that if a policy establishes an inspection must be performed, the official is not free to exercise judgment on whether to do it.
The how doesn't negate the must.
Exactly. And they had a brilliant analogy for this.
Oh.
The court cited Ham v. County of Los Angeles. That court noted that even driving a nail involves some choice.
Driving a nail.
Yes, think about it. You have to decide how hard to swing the hammer, the exact angle when the nail is flush. Technically, those are all judgments.
See where you're going with this.
But the court held that doesn't make carpentry a discretionary governmental function. It's just a task.
Right.
In Peeples, the application was identical. Mr. Karpus had no discretion to skip the inspection. The duty to inspect and report was mandatory.
So the conclusion on that element.
The court concluded it was a ministerial act, not a high-level judgment call.
That distinction between driving a nail and setting policy is really helpful. It prevents the city from claiming everything is discretionary just because humans have free will.
Right.
Let's look at the alternative. Even if the court accepted the city's argument that this was discretionary, how did they apply the identifiable victim imminent harm exception?
This is the safety valve for plaintiffs when the ministerial argument fails. The sub-rule comes from Bonington v. Westport. It says immunity is waived if a discretionary act places an identifiable class of foreseeable victims in imminent harm.
Why did that apply here? Usually the public isn't an identifiable class.
Correct. If a road is bumpy, the general public is affected, so immunity usually stands. But here, the application was specific. The city wasn't just maintaining a random patch of grass.
No, they were prepping a field.
They were preparing a field specifically for a scheduled Little League game.
So the kids on that roster were the identifiable class.
Exactly. And a hole in an outfield where children are running at full speed. That is imminent harm. The conclusion on this element was clear. Even if the act was discretionary, the city would still likely be liable under this exception.
So the city loses on the main test and they lose on the exception. And after analyzing all the elements, what was the court's final conclusion?
The holding was clear. The motion for summary judgment was denied for the city and Charles Carroll. The court held that a jury could find the acts were ministerial, and therefore the city is not immune. They have to face the lawsuit.
Wow. So an informal understanding between supervisors that you shouldn't walk past a pothole turned into a legal obligation that pierced the shield of sovereign immunity.
It shows that standard practice can allow a court to enforce accountability.
This has been a fantastic breakdown. Now, for our listeners, law students, city planners, or just people who want to understand how to spot liability, let's synthesize this. Can you convert the Peeples case into a diagnostic checklist?
Absolutely. If you are analyzing a municipal tort, or if you're looking at an exam question on this topic, use this three-step framework. Step 1 is the classification check.
Okay.
Zoom out. Ask yourself, is the act complained of a high-level policy decision, like deciding budgets or where to build a fire station, or is it a ground-level execution of a rule?
The altitude check.
Right. If it looks like high-level policy, lean towards discretionary. If it looks like driving a nail, lean towards ministerial.
Got it. What is step 2?
Step 2 is the directive hunt. This is the most important step. Look for the must. Is there a charter, an ordinance, or, as we learned today, an informal practice from testimony that says the employee shall or must do X?
And the tip.
If that directive exists, it is likely ministerial liable. If no directive exists and the worker has to figure it out on their own, it is likely discretionary immune.
And finally, the safety valve.
Step 3 is the identifiable victim safety valve. If you find it is discretionary and think the city is immune, stop and check. Was the danger obvious? Was the victim part of a specific group like kids at a scheduled game rather than just the general public? If yes, liable.
That is a powerful tool. Step 1, classification. Step 2, the directive hunt. Step 3, the safety valve. Thank you for that dissection. It really highlights that in the eyes of the law, the difference between a judgment call and a checklist item is the difference between total immunity and paying for the injury.
It creates a fascinating incentive structure. It encourages cities to have clear rules, but it also punishes them when those rules are ignored.
And for you listening, here is a thought to walk away with. We often think of law as something written in leather-bound books by legislatures. But this case proves that we create law in our workplaces every day. If an unwritten rule is enough to create liability, how many informal habits in your own workplace are actually binding legal duties waiting to snap shut? It's something to think about next time you see a procedure that isn't written down. Thanks for joining us on this deep dive.
It was a pleasure.
See you next time.